Police say on October 20th of 2008, Vance broke into Presley's home, raped, then beat her. She died 5 days later, never regaining consciousness. Now joining us this morning is Felecia Epps, a law professor at UALR's Bowen Law School, teaching criminal law and criminal procedure. Thank you so much for being here. A lot of people are watching this case particularly closely, probably the highest profile case we've seen in the state in a long time. Talk about first what is rare about this particular pre-trial hearing, or is there anything rare at all? It just seems that we're getting a lot of information about the case before the actual trial.
Well, I don't think there's anything rare about it. In terms of a defense strategy, it would be kind of commonplace for the defense to try and keep out the evidence here, particularly the DNA evidence and the statements that Mr. Vance made, because as you might imagine, those get in front of a jury, that will be pretty compelling evidence to the jury. So this will be kind of a standard procedure, trying to keep those statements and that kind of evidence out of the case, and then proceeding on to trial and getting prepared for that.
We heard a lot about some specifics in this case, and that's pretty typical in a pretrial hearing of this nature?
Yes, it would be, because the goal here again is to keep that information out of the trial. And so had the defense been successful in what it sought to do, the jury would never know about the DNA evidence, they would never hear the statements that Mr. Vance made, and that would make the prosecution's job much tougher, trying to prove beyond a reasonable doubt, as is the prosecution's burden, that Mr. Vance committed these crimes.
Let's talk a little bit about him taking the stand. We know that his attorneys urged him not to take the stand, which is very typical in a case like this. Is he a defense attorney's worst nightmare in terms of a client for taking the stand? Well,
the defendant normally doesn't do himself a lot of good in exposing himself, particularly to the prosecution's cross-examination here. He's already made a series of conflicting statements, and now he's taking the stand, giving the prosecution an opportunity to cross-examine him, and really hasn't done himself any good, because in the end result, which likely would have happened with or without his participation, sure, those statements are going to come in. And now what they're really going to have to think about is, in terms of trial strategy, is will we put Mr. Vance on the stand again? Will we subject him to that? Because he's now given, counting yesterday's statement, I believe 4 different statements that have been subject to question. But if he
insists on taking the stand again, I mean, they can't keep him off the stand, right?
That is true. Yeah. The defendant gets to make his choice about whether he should take the stand or not. And hopefully his defense counsel will be able to work with him in terms of helping him to see that that might not be in his best interest.
A lot has been mentioned about the now potential jury pool, because so much has been put out there. This is a high profile case, although Judge Chris Piazza, we've been mentioning, has really made a point to make this a very open case. He has said that he won't do a change of venue. He's not interested in sequestering jurors. Mm-hmm. What does this mean for the jury pool, you think?
Well, I think that hopefully, I'm sure you all are hopeful, that a lot of people watch newscasts and get the information that's there, which means that having jurors who have not heard anything about this is highly unlikely. There will be potential jurors who have heard something, perhaps formed an opinion, and I would hope be honest about that when they are go through the trial process, because if they've already formed an opinion in advance of the trial as to Mr. Vance's guilt, or guilt particularly, they are not appropriate jurors. They should not be allowed to serve. So the more information is out there, say if the potential jury pool watched Mr. Vance's statements and has heard those things.
Which he continues to speak out even to reporters, and that's not very typical either.
No, it's not typical. Standard kind of advice to a defense client would be keep your mouth shut. I mean, you don't do yourself any good talking to the press, as he has done, or testifying in these pretrial situations.
All right, well, it's certainly a case many have their eyes on, and we'll continue to watch as it approaches November 2nd. Felecia Epps with the UALR School of Law, thank you so much for being here this morning, and we'll probably talk with you more as this case unfolds.